Hey everyone, Corey Bagby here with Chosen Estate Planning. Most people think estate planning is about documents or money or honestly death. It's not. It's about control and clarity and protecting the people you call home. I came to this work after seeing firsthand how quickly life can flip. From a personal health scare to planning for a parent with Alzheimer's. Those experiences taught me that the right plan, not just a pile of papers, but a real plan, brings order to chaos. And that's why I started Chosen Estate Planning. So in this video, we're going to talk about a common question in estate planning. Do you need a will or a trust? And the answer, especially if you own a home, might surprise you. Before we jump in, I need to get some housekeeping out of the way. This video is for informational purposes only and doesn't constitute legal guidance. I always recommend you consult with a qualified estate planning attorney in your state for your particular situation. So with that out of the way, let's jump in. Let's start with what a will is. A will is actually a set of instructions that tells the court who gets your property and who's in charge when you're gone. But here's the catch. A will still needs to go through probate. Probate's a court-supervised process that distributes your assets. I'm going to go over the 5 essential costs of probate. So for example, here in Illinois, probate typically takes 9 months to well over a year. And it can last for even longer for complicated or contested estates. During that time, your family may not be able to access or sell assets that they rely on. This is the first cost, the cost of delay. And this delay isn't just about time, it's about missed opportunities. So imagine your executor needs to sell stock that's rapidly losing value, or your family needs to sell a home quickly for liquidity. The court's slow probate process will prevent that crucial financial agility. The second cost of probate is the financial cost. Probate can be really expensive. For example, in Illinois, on average, probate costs are approximately $12,000, with the range typically falling between 4 to 8% of the probate estate's value. To put that percentage into perspective, if your probate estate is valued at $500,000, you could easily be looking at $20,000 to $40,000 in costs. That's a massive difference that directly impacts your beneficiaries. Probate fees typically include executor fees, attorney's costs, accounting fees, appraisal costs, court fees, and bonds. That money comes directly out of the inheritance your family should be entitled to. The third cost, and this may initially feel a bit more subtle, is the cost of losing privacy. Remember, probate's public, so anyone can see what you owned, what debts you had, and who's inheriting. This isn't some abstract concern. This public exposure makes your family a potential target. Competitors can see business assets, disappointed distant relatives can suddenly appear, and bad actors can use your public asset list for targeted scams or fraud. Avoiding probate keeps all this sensitive information confidential, which ultimately protects your family from unwanted scrutiny, potential exploitation from bad actors, and public disputes over inheritance, especially if conflict is anticipated. Now, I would characterize family conflict as one of the most damaging and emotional costs of probate. Probate creates uncertainty, delays, confusion, and a lot of pressure on the executor. It also creates the opportunity for situations where old resentments can resurface. This most often happens where instructions are unclear or beneficiaries simply just don't agree. Probate gives them a platform for everyone to argue. This is particularly true for non-traditional families, including blended families or those with estranged relatives. When the estate gets involved, the default rules often prioritize biological ties over your actual intent, fueling potential disputes that can tear families apart. The fifth and the final cost that we'll discuss in this video, the cost of not planning for incapacity. While not technically a probate cost, it is a big blind spot in estate planning. Did you know that up to 80% of Americans will face some form of incapacity in their lifetime? A will activates only after you pass and does nothing for incapacity planning. Without a trust or a power of attorney, incapacity means a court-appointed guardianship. That process is slow and expensive and invasive, much like the probate process. A guardianship proceeding requires a doctor to declare you incompetent, followed by court hearings, lawyers, and potentially an annual review by the judge. It takes your control away entirely. The right planning avoids this traumatic process altogether. So let's talk about an alternative to a will, and that's a living trust. A living trust is designed specifically to skip the court process altogether. With a living trust, you write the rules, you stay in charge while you're here, and when you pass away, your chosen successor steps in seamlessly. No court, no headlines, and no waiting. Think of a living trust like a secure container you create during your lifetime. You're the one who's in control, you're the trustee, and you can put assets in, take assets out, change the rules, or dissolve it entirely. Inside this trust, you place things like your home, bank accounts, investments, and personal property and other assets that you want to protect. That process is called funding. A common mistake people make is having a trust, but never actually changing the title on their home or bank accounts to the name of the trust. If an asset isn't funded, it's not protected by the trust and will still need to go through the probate process. Because with a living trust, you stay in control, nothing about your daily life changes. You use your money, pay your bills, buy and sell property, just like you do now. But if you become ill or injured or unable to make decisions, your successor trustee, the person that you choose, automatically steps in to manage your affairs. They can pay your bills and handle your medical or long-term care costs. They can manage your home and protect your investments. And unlike with a will, they don't need to go to court for permission to do so. This avoids an expensive guardianship proceeding and keeps everything private. When you pass away, your successor trustee takes over again, but this time to distribute your assets. Here's the key difference. With a trust, your family avoids probate. Your trustee simply follows the instructions you wrote: who gets your home, how your money is distributed, whether your children inherit at certain ages, protections for blended families or special needs beneficiaries. All of it stays private. Everything stays efficient, and everything happens according to your values. And let me tell you, if you've been putting this off, you're not alone. But here's the truth. Estate planning isn't just for the wealthy or the elderly. It's for anyone who loves someone enough to protect them. At Chosen Estate Planning, we meet you where you're at, whether your family's traditional, blended, or chosen. We specialize in crafting customized plans that address the unique challenges of modern Illinois families, providing robust protections where generic online forms simply fail. We use secure modern technology. You'll meet directly with an attorney, not a chatbot or some generic form. We're here to make sure your plan actually works when life happens. So take that first step. Call us or visit www.chosenestateplanning.com and schedule your complimentary discovery call. On that call, we'll answer your questions, explain your options, and help you see exactly what your next step looks like. No pressure, no obligation, just clarity.